The next case is a mini oral argument on the application. It is Hahn versus Geico.
May it please the court, Daniel Saylor appearing on behalf of the appellant Geico Indemnity. If the court please, I'd like to reserve 4 minutes for rebuttal. The issue before the court is the validity of the Farm Bureau versus Allstate, what I've been calling the Farm Bureau versus Allstate Reformation Rule. And the relief we're seeking in this appeal is that the Farm Bureau versus Allstate rule be disavowed, that the court overrule that case, and that the lower court rulings against Geico in this case be reversed with a directive that summary disposition be granted in favor of Geico. Now, if I may, very briefly, Your Honors, I'd like to put the issue in context in this case, how it arose. Plaintiff's claim against Geico at its core is a contract action seeking payment of Michigan no-fault benefits based on the contract of auto insurance Geico issued to Zachary Waller. Now, if plaintiff is entitled to recover, it must be because the contract provides, or by some statute is deemed to provide, for the payment of such benefits. Well, we know the actual terms. This is a North Carolina auto policy. The actual terms of the policy do not provide for this recovery. One statute can, if applicable, require Geico to pay Michigan no-fault benefits based on its non-Michigan policy. And that would be the prior 500.3163. As of June, it no longer does that, but it did it this time. So if applicable, that statute can require Geico to pay Michigan no-fault benefits, notwithstanding it's a non-Michigan auto policy. And in fact, when the claim came in, Geico paid benefits on the premise that it was dealing...
Counselor, can I ask a question? Well, first off, I just want to understand, if you could help me to understand, why didn't you raise this issue about Farm Bureau? Why didn't you argue it should be overturned in the lower courts? I realize that you're arguing it now, but why wasn't this raised before?
Well, Your Honor, frankly, it arose not by, plaintiff did not even assert that theory. It was, plaintiff pursued, when Geico denied the claim, actually it didn't deny the claim, it sent a letter saying, we are honoring your claim and we are paying $500,000 of benefits under the auspices of being deemed under 3163 to pay no-fault benefits. Plaintiff then sued saying, well, we want unlimited no-fault benefits, and it also sued Auto Club as a potential alternative recovery based on resident relative. Both defendants moved for summary disposition, and Auto Club first said, well, no, she wasn't a resident relative of our insured, her father, but if she was, it was a priority defense that Auto Club raised, saying, raising Farm Bureau versus Allstate case, saying, oh, well, the Geico policy should really be treated as if it were a Michigan policy, and they'd be higher in priority. So plaintiff's only response to Geico's summary disposition motion, which had said, look, our policy doesn't provide for it, and if 3163 applies, we paid what we owe. If it doesn't apply, then we really didn't owe anything. We're not asking for our $500,000 back, but we don't owe anything further, that's for sure. So the plaintiff's only response was not anything about Farm Bureau. It was about, oh, well, we think that your letter relied on 3163. You can't say that that doesn't apply now. It was a little, I would say, nonsensical. It was hard to follow how that expands to full coverage when they paid their $500,000 under the sub 4 of the statute. But in any event, that's where things were when the court, without any oral argument, issued its opinion, dismissed Auto Club from the case based on no resident relative, and then said the plaintiff can proceed against Geico on two theories. One was this unusual estoppel theory, which the Court of Appeals ultimately rejected, and two, based on Farm Bureau versus Allstate, which, again, the plaintiff had never raised, but that's something that Auto Club had brought up. So the circuit court proceedings, then we applied for leave, and we've been on appeal ever since.
But when the Auto Club brought it up, didn't you have an obligation at that point to respond and say, we think it's wrongly decided?
Well, it was...
I mean, Auto Club's pointing the finger at you when they cite the Farm Bureau.
That's right. We argued that it doesn't apply. As far as saying that it doesn't, that it should not be followed, I can't tell you why it wasn't raised, other than I would say that sometimes at the trial level, attorneys don't often think about a published opinion saying, well, don't follow that.
Okay, so let's take it a step further. You get a ruling against you, take an appeal. Do you cite that Farm Bureau was wrongly decided in your application to the Court of Appeals?
Well, the Court of Appeals certainly felt that we did not articulate that well, or argue that it was bad law. It was kind of a, they granted leave, and of course they included the language, you know, the appeal is limited to the issues raised in the application. So I acknowledge that that aspect of the Court of Appeals proceedings, but it surely was fully briefed in the appellant's brief, fully responded to in the appellee brief, addressed more in the reply brief. And even though the Court of Appeals said that, well, you didn't raise this in your application and we had this order, it proceeded nevertheless to address the merits and said we agree that this is binding precedent, and both the trial court and we are bound by that holding.
So you don't think you have a preservation problem?
Well, I addressed that in detail in my reply brief to the response to the application filed last January, a year ago. It's laid out there in detail. Frankly, I perhaps unwisely read the court's order granting supplemental briefing and this argument as a suggestion that the court was interested of moving beyond that potential waiver issue to the merits of the question as to whether that Farm Bureau case is good law or whether it should be overruled.
Mr. Saylor, to follow up on Justice Zara, the Court of Appeals relied on two procedural grounds: failure to preserve in the trial court and failure to raise the issue in the application for leave to appeal. And those were the justifications for rejecting your challenge to the correctness of Farm Bureau. Yet in your application for leave to this court, you don't seek review of either of those two procedural holdings on the part of the Court of Appeals. Doesn't that just compound the preservation problem from your perspective?
I don't believe so, Your Honor, because I think the Court of Appeals effectively gave us a pass on that. First of all, on the first of the two, about it not being raised in the circuit court, it acknowledged that issues can be reviewed, when it's a pure issue of law, as this was, and they, in the Court of Appeals decision, acknowledges that, and then it says, and then it proceeds to the next point, and points out that it was not raised in our application. It then, nevertheless, proceeds to address the merits and say that we believe that the Farm Bureau decision is binding precedent. It didn't go to any length to buttress it and say, yeah, here's the rationale, we think it's a great decision, or we don't think it's a great decision. But it didn't really need to. It said, we reject your suggestion that it's dicta, and instead conclude that it's binding precedent. And so it's certainly the controlling ruling in this case, and it affirms that it is binding precedent on future cases and all insurers who issue out-of-state policies and have to worry about whether a court might apply this rule and trigger unlimited Michigan no-fault benefits. So as I say, these arguments on the preservation issue are laid out in more detail in our reply brief filed 1 year ago.
Can I ask you a different procedural question? My understanding is there are not facts yet determined from which we could decide whether Farm Bureau even applies in this case, right? The trial court has not yet found whether the policy here was issued or delivered in Michigan, or whether Geico knew or should have known that Waller was a Michigan resident. Like, those facts are not yet determined. Is that correct?
The circuit court and the Court of Appeals both looked at the facts, and it's true. They said that the plaintiff has a jury submissible claim on this notion that Geico knew or had reason to know that they were dealing with a Michigan resident. And both opinions laid out why they think it's not just a jury question, they think it's a very strong, they basically said that this is, they didn't sua sponte grant partial summary in plaintiff's favor on that, but they certainly felt like the foundation is there to proceed with the claim. And
But if a jury finds that one of those things is not the case, then your client wins and Farm Bureau doesn't apply. So if we were to issue an opinion in this case saying Farm Bureau was wrongly decided, is it an advisory opinion?
No, I don't think so. I think that the appellate courts frequently will grant interlocutory appeal to address the legal premise of the case and whether there are still questions of fact.
Even if Farm Bureau doesn't govern this case, we can still say, but, we have the opportunity, so let's say we don't like it. It might not govern here, but somebody in the future would benefit. I'm just
Well,
trying to
it
understand.
potentially applies here. I mean, on the facts, it very potentially applies here, and I think that's all the court
Potentially
needs
applies
to issue a
enough, yeah.
ruling.
Okay, understood.
I don't think you're the least bit prohibited from examining the legal premise of that opinion. And insofar as that opinion goes, the question, again, that we're addressing according to the court's order is whether or not that opinion is essentially well-founded, whether the rule it creates is well-founded. And quite frankly, it is not well-founded. We know that if Geico is obligated to pay unlimited Michigan no-fault benefits, or to pay Michigan no-fault benefits at all based on this auto policy it issued, it can only be because of one of two things. Either the contract terms provide for it, or some statute deems that the contract provides for it. And we know the terms don't apply. And the only statute that might apply would be the 3163. And now we're to the point in the litigation where we know that that's not the premise where plaintiff can proceed, because if it applies, Geico paid everything it was obligated to pay. And so we come to the Farm Bureau, and the Farm Bureau relies on, it purported to rely on a statute that says, yes, the out-of-state policy has to pay Michigan no-fault benefits, but it's clear that the statute it cites does nothing whatsoever like that. The statute, by its terms, just creates certain insurance policy content requirements by referencing the preceding sections of statute, such as, and I've referred to them, that a liability policy has to declare that even if the insured is declared bankrupt and has their liabilities absolved, it does not absolve the insurer from paying up to its policy limits. That's one. Another one, interestingly, is Section 500.3010, which at this time and today, that just speaks about, that if your car if there's a fire loss or something, then you have to report to authorities before you claim, to avoid possible arson. You have to report it to the authorities. But 3012 has been around for a long time, I think since 1957, and it hasn't been changed. 3010 used to be the provision that required uninsured motorist coverage in a liability policy. And so you get to 3012, and it says any policy issued in Michigan, any liability policy issued in Michigan that doesn't have these provisions will not render that policy invalid. We will just deem that the policy contains those provisions, such as you didn't include UM coverage, but we'll deem that it has UM coverage up until that was taken away in 1972. But that's the type of content requirement that 3012 speaks of. And obviously, there's nothing close to the content requirement that the Farm Bureau opinion imputed to it. Instead, the court engaged in judicial legislation at its most base level. It felt like the purpose of 3012, sorry? I thought it was a question. It felt that the purpose of the statute was a good one, and so they said, well, that sounds like a good idea, and they fashioned an altogether different content requirement for non-Michigan policies, no less, and thus judicially expanded and greatly amended and expanded the statute without any textual support. They didn't even try to find textual support for the ruling.
Am I right that the dissent in that case, the only critique was that the majority didn't go far enough?
Correct. Yeah, that's the thing. Both the majority and the dissent try to say that that a policy issued under these circumstances, i.e. when the insurer knows or had reason to know that they're dealing with a Michigan resident, it would be, the dissent said, an illegal policy. And the majority said it would violate Michigan no-fault law if they issued such a policy, and that's the justification for reforming it. But, and this goes to the question of whose job is it to decide what insurance I need to buy for my car? Because that logic that it would be an illegal policy presupposes that the insurer, in that case, it was Indiana. They come in and they sit down, hi, I want to buy an auto policy, an Indiana auto policy.
Counsel, I see where you're going with this, but, now I have to ask a question. I mean, because you kind of took us down this road, and I realize time is short, but,
Time is over, actually.
Time is
Just-
actually over, but
Yeah.
I just have to
Very,
ask.
very
'cause-
short.
Okay.
Over.
But you did kind of take us down this road, but the person's a Marine. He has a Michigan license. I mean, I realize the facts have to be fleshed out, but, because we haven't developed the facts yet, but, how do you respond to that? I mean, the fact here is that he doesn't live in North Carolina. He's a Marine. He's stationed there, but he doesn't
Right.
live there. He has a Michigan driver's license. I mean, he
Right.
doesn't, this isn't someone who, even vacations there or has any connection to North Carolina other than the fact that he's in the Marines and is stationed at, I believe, it was at Fort Bragg, and was stationed there. He's a Marine. He's there because that's where he's stationed, but he's not living there.
Well, if I may, and it's a perfect question, let us stipulate for the sake of this argument that the Geico agent that sold him insurance down there recognized the Michigan resident, the Michigan driver's license, and understood that this person hails from Michigan. The fact is, he was obligated under North Carolina law to buy, because by North Carolina statute, anyone in service and staying at Camp Lejeune
Camp
or
Lejeune,
any
I'm sorry, Camp
military
Lejeune,
base,
sorry, Camp Lejeune.
they're obligated to, if they own a vehicle, they're obligated to register the vehicle in North Carolina, and he did so. He was required to do so. And also, any person required to register their vehicle in North Carolina is obligated to maintain North Carolina insurance during the period of the registration. That's in our briefs. So what happens is this person was in fact obligated to buy the very insurance he bought, and now under the Farm Bureau ruling, we're supposed to understand that.
Thank you, Mr. Saylor. I think
You get that
Yeah,
point.
I
We get the
understand
idea,
your
and time has long expired. Thank you very much.
Sure.
Well, I can't find the button. I've never been very well mechanically inclined, so there's part of my career choice for you. Good morning, may it please the court. Don Fulkerson appearing on behalf of the plaintiff appellant, Kaitlin Hahn. In the window here, I want to stress just a few things. First of all, yes, this is an unpreserved issue. There was never a challenge to the propriety of the Farm Bureau versus Allstate decision in the trial court or in the Court of Appeals application. The Court of Appeals never reached this issue and pointed out there was a lack of issue preservation. And so here we are. I mean, we don't have a preserved argument regarding whether or not Farm Bureau was or was not correctly decided. Second of all, I'd point out, and Chief Justice McCormick indicated this, there's an issue here about whether or not this was or was not a Michigan policy that is undeveloped in the record. As the Court of Appeals pointed out in its decision, there was a very limited agreement regarding discovery. It was only partial discovery conducted, so there could be motions for summary disposition. The issues regarding what Geico knew or should have known at the time Zach Waller took out the policy, where was it delivered, and was it in fact a Michigan policy or a North Carolina policy. Those issues in the record are undeveloped. If it is in fact a Michigan policy, I think we have a slam dunk here that the policy did require Michigan no-fault coverage. Now, having raised that argument about the delivery issue and the fact that this may very well, we don't know, but this may very well be a Michigan policy, in Geico's reply brief and in Member Select's amicus brief, they raised this choice of law argument. I would submit that this is another unpreserved argument. You can't raise an argument for the first time on appeal in a reply brief. The choice of law provision argument was never previously asserted either in the trial court or in the Court of Appeals or in their Supreme Court application or in their Supreme Court supplemental brief. But if the court is somehow inclined to consider this, which I think the issue is clearly waived, I would point out that the Chrysler versus Skyline case talks about enforceability of a choice of law provision and says, look, it is still unenforceable if it is, and it cites Restatement of Conflicts, Section 187, Paragraph 2B, if it's contrary to a fundamental policy of Michigan, which had a material greater interest than North Carolina in determination of the particular issue. Now, I agree that both Michigan and North Carolina have interests here, but Michigan clearly has the paramount interest regarding the issuance of a policy that has mandatory PIP coverage. Yes, Mr. Waller he registered his GMC Sierra in North Carolina, and he took out a North Carolina policy. But North Carolina did not require PIP. It only required the residual liability, third-party liability coverage in that state. So North Carolina has absolutely zero interest regarding whether or not this policy should or should not have Michigan no-fault coverage. And therefore, Michigan has the paramount interest, in the choice of law provision would accordingly, under Chrysler versus Skyline and under the restatement, would not be enforceable anyway. And I could cite you with some additional cases if you would like, because this issue was just raised less than a month ago in both the final reply brief by Geico and in Member Select's amicus brief. Now, so, I mean, if we have a Michigan policy, I think we're done. We have a Michigan insurance company authorized to do business in Michigan. If the policy is delivered in Michigan to the resident of Michigan at the resident of Michigan's address, it is a Michigan policy, and therefore PIP is mandatory under 500.30094 unless Geico provided documentary evidence of deletion of the mandatory coverage to the insured. That is the case whether or not it is or is not a Michigan policy. I mean, so I talked about, and the reason why I raised the Johnson decision and whether or not the majority decision was correctly decided or whether Judge Beckering's decision was correctly decided was because in Geico's supplemental brief, they rely at some length on the majority decision in Johnson versus USA. But it's clear that this is, if it's a Michigan policy, it had to have PIP unless Geico provided evidence of the deletion, and they did not, so there has to be PIP coverage. Now, if this is not a Michigan policy, it is a little bit more of a difficult question. And I submit that we still have, one, an undisputed fact that because Zach Waller was a Michigan resident, and because this vehicle was being driven on Michigan roads, Michigan PIP coverage had to be provided. And that therefore, since PIP coverage was mandatory under both 257.216 and 500.31011, and there are only two exceptions to the mandatory nature of PIP for a Michigan resident driving on a Michigan road. One is if you're a non-resident and you're on the road less than 30 days. Well, he's a resident, so that exception doesn't apply. And the other exception is 500.3017(1)B, and that is transportation network company vehicles. Well, we don't have a transportation network company vehicle, so you have mandatory PIP. So if you look at the language of 30.09.4, it doesn't matter where the vehicle is garaged. They make the argument, well, the vehicle was garaged at Camp Lejeune down in North Carolina. That doesn't matter. The statute doesn't talk about a geographic requirement of where the vehicle is principally garaged. It just says, if you issue a policy, you have to provide notice of the deletion, otherwise it's mandatory. And so that's why it doesn't matter whether it's a Michigan policy or not, because 500-3012 says we enforce provisions 3004 through 3012. It's enforceable. And that's the argument. And unless the court has any questions, I appreciate your time. Yes,
I
Justice
do have a
Martin.
question, counsel. Given that Geico has apparently preserved its argument that the policy here doesn't purport to be a Michigan policy, and given that discovery is incomplete, and given that there seems to be at least some question concerning the assertions in Farm Bureau progeny cases that residency is the exclusive consideration in determining what a Michigan policy is there some basis for this court to consider expounding upon whether those cases are correct?
Well, I agree with the statements made that without a record here, we kind of have an unripe issue for determination.
I'm asking whether there's some merit to this court expounding on what the standards are, what the tests are.
I think the court has the discretion in this case to expound. I think you do. I mean, I think you would have the discretion to do so.
Would you urge us to do that? To exercise that discretion affirmatively?
I would leave it to the court. I think that this case may well be served by a remand and a development of discovery and possibly a settlement of the case that would alleviate the need for further appellate review. And again, if on remand there's a determination this is a Michigan policy, I think all bets are off. I think if it's a Michigan policy, then the Farm Bureau issue goes away, because Farm Bureau only applies, is based on the assumption of a non-Michigan policy.
It may or may not be a Michigan policy in the end. I'm not trying to foreshadow what that result is, but you are cognizant, I guess, do you agree with the proposition that a Michigan resident could be reasonably seeking out a North Carolina policy, and a North Carolina resident could be reasonably seeking a Michigan policy? In other words, residency is not the exclusive factor in assessing whether something is or is not a Michigan policy.
Well, I agree that scenario is possible, but I think that if a Michigan resident seeks insurance in North Carolina, and the carrier is a Michigan certified insurance company, and remember, the Gordon case, the unpublished Gordon case, was decided in 2012, 2 years approximately, or a year before, no, 3 years before this case. Geico clearly understood as a carrier that if we're issuing a policy to a Michigan resident and we're certified to do business in Michigan, and PIP coverage is mandatory, we have an obligation to provide coverage, particularly if we deliver the policy in Michigan. Particularly if we do. Now, if we don't, my position is the statute still requires, if you're not going to provide Michigan coverage to a Michigan resident, you have to provide documentary evidence of the deletion, which is, by the way, what USA Casualty did in Johnson. And that's why I think, even though you don't really have to get to Johnson, because Johnson is distinguishable. It's undisputed here. We have no documentary evidence provided by Geico that we're not providing Michigan PIP. And I think because they're a Michigan insurance company, they have to do that. Thank you again.
Thank
And
you,
Happy
Counsel.
New Year to everybody. Thank you.
Thank you. The case will be submitted.